Hello, everyone. Welcome to Rocky Watch, our series of public policy broadcasts. I want to thank you all so much for taking time out of your busy days to join us at this event, which could hardly be more timely. I'm sure you'll all have lots of questions for our speaker, so feel free to use the chat button or the Q&A button at any point in this broadcast to ask your questions. And now would be a good time for me to introduce Ben Vogley. Ben, do you want to come on and say hi?
Hello, everyone.
Ben's a junior at Dartmouth, and he will be relaying your questions to Ms. Greenhouse. It is my great delight to introduce today's host. Research Assistant Professor Herschel Naklis of the Government Department. He's also a policy fellow at the Rockefeller Center. Thanks so much for being with us tonight, Herschel.
Great, thanks so much, Joanne. And welcome, everyone. It's great to see all of us gathered here for this important conversation. As Joanne said, I'm Herschel Naklis. I'm a professor in the Rockefeller Center and in the Government Department here at Dartmouth. And on behalf of the Center and the Legal Studies faculty group, it's my great pleasure and great honor to welcome this year's Constitution Day speaker, Linda Greenhouse. Greenhouse is the Knight Distinguished Journalist in Residence and the Joseph M. Goldstein Lecturer in Law at Yale Law School, a contributing op-ed writer for the New York Times. And before this, for 30 years, she was a Pulitzer Prize-winning reporter on the court and American law and politics for the Times, and also in her spare time managed to write 5 fantastic books. Greenhouse is a graduate of Radcliffe College and Yale Law School. And to our many students on the call who don't recognize the name Radcliffe College, I would strongly encourage you, once the talk is over, to Google it and consider that history for a few moments. Now, it's through Linda Greenhouse's brilliant reporting and commentary that so many people for over 4 decades have come to understand, interpret, and respond to changes on the Supreme Court and in American law. Indeed, there may be no better single person equipped to offer insight on the Supreme Court, American law, and American politics than Linda Greenhouse. And that's particularly so in these times. These are times of intense political polarization. The recent death of Justice Ruth Bader Ginsburg, a Supreme Court increasingly cast as politicized, and an impending presidential election that may well end up being decided in part by that court. And so before turning the microphone over to our guest, it's worth emphasizing 2 specific features of Greenhouse's work that have always stood out to me and which our students and really all of us could learn a lot from. First, Greenhouse's work always combines deep legal analysis and deep political analysis. And so often these 2 spheres are artificially separated. It's either all law or all politics, even though, as Greenhouse's work consistently shows, any true analysis requires understanding both law and politics and their many interactions. And second, Greenhouse's work combines this empirical rigor and depth with normative concern and normative bite. So often these 2 spheres are also artificially separated. Something's either an empirical question about what is or a normative question about what ought to be, even though, as Greenhouse's work shows us, the best analysis, the most impactful, most valuable analysis, the analysis truest to our democratic values and aspirations, requires both empirical rigor and normative gravity. Now, today's talk is no exception. The talk is entitled, "Aren't We All in This Together? How the Supreme Court is Helping to Pull Us Apart." And so we're delighted to welcome Linda Greenhouse to Dartmouth, delighted to see all of you here. I'm very much looking forward to the conversation. And to that end, I will turn the microphone over to our guest.
Thank you, Herschel. I have to say that's one of the nicest introductions anybody ever gave me. And I wish you and I could just pull up a chair and talk about journalism. Because I very much appreciate what you just said. So here we are, just a few days after Ruth Ginsburg's death, and of course I could spend the next hour talking about her, but I'm not going to do that. I'd be happy to take some questions. I'm going to proceed with what I had planned to say in this gathering, and what I'm going to do, as you'll see, is drill down rather deeply and rather specifically on a couple of recent Supreme Court activities, because I think as Herschel suggested, a lot of times we the Supreme Court comes to us in kind of sound bites or in just the ultimate judgment. And what's really important to understand, especially now, you know, how conservative will the court be? What does it mean to be a conservative on the court? What does it mean to have a liberal court? If anybody can remember that far back. You know, and the devil is really in the details. It's deep in the weeds. So this talk may seem a little bit weedy, but it's in the spirit of we really understand the court by seeing things as they're seeing them. But let me start by just recounting a little anecdote that I think kind of frames what I want to talk about. So in late summer, my husband and I took a ferry across Long Island Sound from New London, Connecticut to Orient Point on the North Fork of Long Island to visit some old friends. This was our first trip away from home since the COVID pandemic had struck in March. And of course, we were concerned about the safety precautions that we could expect on the ferry. We were reassured that both the ferry company's website and the signs posted prominently in the terminal and on board told passengers that masks were required. So I was quite surprised once we took our seats on the covered deck. I should say we would have sat outside, but it was raining quite hard and every other booth on the deck was closed off for social distancing, to see two people seated quite near us without masks. I looked around for a crew member, but seeing none, I went over to the man two booths away and I said, "Excuse me, you're supposed to be wearing a mask." He looked startled and rather embarrassed, and he reached into his pocket to pull out a mask, which he promptly put on. Then I went to a woman sitting behind me who was absorbed in her needlepoint. "Excuse me," I said, "you need to be wearing a mask." She didn't look up or otherwise acknowledge my presence. So I repeated a bit louder, "You need to wear a mask." She looked up, staring at me coldly for a long minute, and then said, "I heard you." She then went back to her needlepoint. Eventually, after a couple more people had confronted her, she left her seat and moved elsewhere. So why am I beginning a Constitution Day lecture by telling this story? I think it well illustrates a challenge that the United States is currently facing. Not only the pandemic that has so profoundly disrupted our lives and that has me addressing you virtually rather than spending a nice autumn afternoon in Hanover. It's not a constitutional challenge, and yet in a deep way, it is. It's a fracturing of our sense of community. The loss of a belief that however the problem facing the country could be defined, we are all in it together. The Constitution can't create community. It wasn't even, as our new focus on the country's origins has emphasized, the product of community, once we acknowledge that its privileges were reserved for the propertied white men who wrote it. But the Constitution needs a community, a shared commitment to our common good to sustain it, or it's just a piece of parchment under glass at the National Archives. You may think that I'm about to talk politics. I'm not, at least not in the narrow sense of focusing on the upcoming election. My professional life revolves around the US Supreme Court, its history, the people who currently serve on it, and the impact of the cases it decides. So I'm going to discuss a small handful of those cases with you because I'm quite worried, and I was worried before Ruth Ginsburg died, and now I'm more worried, that the Supreme Court, as much as any other institution in our country, is contributing to the fracturing of community that my experience on the ferry brought to mind. So as I said, I'm going to get pretty far into the weeds of these cases because it's the details that serve the educational mission of Constitution Day as Congress designed it when it designated the day in a 2004 law and required all educational institutions to observe it in some way or risk losing their federal grants. So I'm here to preserve Dartmouth's ability to get federal grants. Most undergraduates don't have a chance to see the court at work, even virtually, although the court recently announced that it's going to continue its virtual arguments for the session that begins on the first Monday in October. So everybody can hear them on C-SPAN or dial in, I guess. So I've just leveled a pretty serious charge at the Supreme Court that is contributing to the breakdown of community in America. It's what we might call the erosion of civil society. So I propose to make my case from the ground up, and we'll see at the end whether I persuaded you. So I'm going to begin by setting two texts side by side and inviting you to compare them. The first is a paragraph from Justice Potter Stewart, long ago justice, from his opinion for the Supreme Court in a case called Abood against Detroit Board of Education. It was a labor case decided in 1977 by a vote of 9-0. The question in the case was whether the First Amendment right of free speech and association, gave public employees who chose not to join a labor union the right to opt out of paying that portion of union dues that provided the union with the resources to fulfill its duty to represent and bargain on behalf of everybody in the bargaining unit, as federal law requires. In other words, that issue was the constitutionality of what's known as the agency fee, under which nobody has to join the union, but all who don't have to pay their fair share for the benefits that everybody receives. In this case, Abood, the objecting employees argued that the system subjected them to an unconstitutional degree of what they called ideological conformity. This is how Justice Stewart, writing for the court, analyzed the problem. He said, to compel employees financially to support their collective bargaining representative has an impact upon their First Amendment interests. An employee may very well have ideological objections to a wide variety of activities undertaken by the union in its role as exclusive representative. To be required to finance the union as a collective bargaining agent might well be thought to interfere in some way with an employee's freedom to associate for the advancement of ideas or to refrain from doing so as he sees fit. But, and here's the nub of this, such interference as exists is constitutionally justified by the legislative assessment of the important contribution of the union shop to the system of labor relations established by Congress. And here, Justice Stewart then quoted an earlier opinion by Justice William O. Douglas. He said, the furtherance of the common cause leaves some leeway for the leadership of the group. As long as they act to promote the cause which justified bringing the group together, the individual cannot withdraw his financial support merely because he disagrees with the group's strategy. The furtherance of a common cause. So hold that thought as I turn to my second text, but first I have to give you a little bit of context. So early last year, a federal district judge in Philadelphia granted an injunction barring enforcement of new rules that the Trump administration had just issued, exempting employers with religious or, quote, sincerely held moral objections to contraception from the requirement in the Affordable Care Act, Obamacare, to provide birth control along with other preventive coverage in their employee health plans. This judge, Wendy Beadlestone, noted the remarkable breadth of these exemptions, which apply to for-profit as well as nonprofit businesses. She noted that Congress had considered and objected a broad conscience opt-out from the birth control mandate. The new rules, she said, thus violated the plain command of the statutory text. And she observed that if enforced, the rules would cause thousands of women to lose insurance coverage to which they were legally entitled. And now to my text. The response of the press secretary of the U.S. Department of Health and Human Services to Judge Beadlestone's ruling. Quote, no American should be forced to violate his or her own conscience in order to abide by the laws and regulations governing our health care, unquote, said Caitlin Oakley. So the story I have to tell really inhabits the space between Justice Stewart's invocation of our common cause and Ms. Oakley's seeming obliviousness to the welfare of thousands of American women who happen to work for bosses who don't like birth control. I argue that these two texts stand as goalposts at the end of either end of a playing field known as civil society. If the two appear asymmetrical, one a statement by the Supreme Court in a published opinion, the other a remark by a federal bureaucrat in immediate response to breaking news, the asymmetry was only temporary. Judge Beadlestone's opinion, not surprisingly, reached the Supreme Court after a stop at an intermediate court, and the court in a case just this past summer called Little Sisters of the Poor against Pennsylvania overturned it. So what was the harm of that? The United States, after all, has a proud tradition of protecting minorities who assert claims of conscience against mainstream norms that would overwhelm or even crush unconventional practices and belief systems. If the political system has often failed to extend such protections, the courts have done so. Such Supreme Court decisions as Sherbert against Verner, which protected a Seventh-day Adventist from having to work on her Sabbath, Wisconsin against Yoder, which exempted the Amish from having to send their children to high school, are well known to anybody with a passing familiarity with the history of the First Amendment's free exercise clause. These decisions are celebrated in many quarters as symbols of American society's commitment to freedom of conscience, of the protection of conscience as an essential aspect of civil society. The Civil Rights Act of 1964 protects religious claimants from employment discrimination and requires employers to accommodate the needs of religiously observant employees as long as the accommodation will not impose undue hardship on the conduct of the business. The conservative writer Ryan Anderson, in an argument against same-sex marriage, observed that, quote, religious liberty plays a crucial role in preserving civil society as something separate from government. Few of us would argue with that statement as an expression of abstract principle. But given recent developments in our politics and our law, we need urgently to move from the abstract to the concrete and to question whether conscience claims, as they're being expressed and honored today, rather than embodying the best of civil society, have become a threat to it. So with that introduction, I want to focus our attention on the court and to begin on an important decision from 2 years ago, a decision that I doubt many of you have heard of. It was a labor case called Janus against American Federation of State, County, and Municipal Employees. And the question in Janus was whether to overrule our old friend, the Abood case from 1977. To the surprise of absolutely no one, that's what the Supreme Court did. And for reasons I'll describe, that outcome, even the vote of 5-4, had been expected for some years. The decision didn't go unnoticed, but few people fully comprehended just how radical this decision was and how much it tells us about the current Supreme Court, the state of our constitutional law, and the emerging impact on the court's constitutional vision on American society. Janus is worth examining from several angles, and I'll just lay a foundation for the case so that we can see it as a whole before I get to the most important point, which is what the decision suggests about the Supreme Court's role. So I'll begin briefly with the First Amendment. It's hard to be brief about the First Amendment, but I'll try. So from today's perspective, the mediated view of the First Amendment that the court expressed all those years ago in Abood, that the First Amendment provides a framework for balancing the collective interests of the state against the interests of private speakers, seems to come to us now from a different era. It was an era when the First Amendment served to enable free and open public discourse, an era before the First Amendment was turned into what it's become, a potent tool of deregulation. The shorthand for what Justice Stewart offered as the rationale for Abood came to be known as the free rider problem, the notion that peace in the workplace would be threatened by the presence of fellow workers who weren't paying their fair share. And it's worth noting that a series of decisions following Abood made clear that the fair share obligation extended only to the expenses of collective bargaining and representation. In other words, employees could opt out of paying for expenses connected with the union's political advocacy, and few people question that dichotomy. But the Janus majority in this recent case found that any such distinction was unworkable as a means of solving what it viewed as the central problem of coerced speech. Because as Justice Alito explained, quote, petitioner strenuously objects to this free rider label. He argues that he's not a free rider on a bus headed for a destination that he wishes to reach, but is more like a person shanghaied for an unwanted voyage. So of course, Janus will extend a substantial price for public employee unions. It's no coincidence that public employee unions have long been a target of political and judicial conservatives, even as union membership in the private sector shrinks almost to invisibility, standing now at just 10% of the private workforce. Union membership is actually quite robust in the public sector, where more than a third of employees are union members, and they tend to skew progressive. These unions tend to support Democrats. So what does Janice tell us about the Roberts Court? I think we can conclude without exaggeration that no precedent is safe. Janice provides a roadmap for how to hollow out a precedent so completely that it just takes a baby's breath to deliver the final blow. And I can't emphasize enough the extent to which overturning Abood was the project of a single justice, Samuel Alito. And here in brief is how he did it. It's quite a tale. It began in 2012 with a case called Knox against Service Employees International Union. It was a narrow question. How that union, that public employees union, should have treated a special dues assessment and what accommodation it should have offered to those members of the bargaining unit who didn't want to pay. But Justice Alito, in a decision signed by 5 justices, went way beyond the question presented to place Abood squarely in the court sights. He said, our prior decisions approach if they do not cross the limit of what the First Amendment can tolerate. And he said, in any future case, the general rule that individuals should not be compelled to subsidize private groups or private speech should prevail. This was, of course, an invitation to bring the court more cases. And the next one arrived 2 years later, a case called Harris against Quinn, another 5-4 decision with another majority opinion by Justice Alito. It held that Abood did not apply in the context of unionized home health care workers due to an employer-employee relationship that's very different from a conventional workplace. Again, he went further than necessary. He announced that Abood was a questionable opinion from the start. It failed to appreciate, he said, the conceptual difficulty of the fact that in the public sector, both collective bargaining and political advocacy and lobbying are directed at the government. So Quinn had been brought to the court by the National Right to Work Legal Defense Fund, which in its briefing asked the court directly to overturn Abood, just get it over with. That wasn't necessary, Justice Alito said, not necessary yet. Justice Kagan, in an opinion for the 4 dissenters, saw what lay ahead. There was no principal distinction between this case and Abood, she said, and therefore no need for the majority's extended discussion of Abood's supposed deficiencies. She said, she's a very vivid writer. Today's opinion takes the tack of throwing everything against the wall in the hope that something might stick, and it would stick soon enough. The following year, 2015, a case called Friedrichs against California Teachers Association reached the court. This was the first case since Justice Alito began his campaign that squarely presented the issue in a posture that gave the court a clear choice: reaffirm Abood or overturn it. The litigation was financed by the conservative Lindy and Harry Bradley Foundation through its grantee, the Center for Individual Rights. Bradley also financed, at least in part, 11 of the organizations that filed friend of the court briefs on behalf of the plaintiffs at the court. This case followed a very unusual path to the court. In federal district court, the plaintiffs did not contest the union's motion for summary judgment. The union said, look, the law is settled on this, just dismiss the case, which of course the district court had to do following Supreme Court precedent. So they then went to the Court of Appeals, the Ninth Circuit, and asked the Ninth Circuit to affirm their defeat because they wanted to get up to the Supreme Court. Obliging, as settled law required, the appeals court affirmed in a 1-paragraph order calling the case so insubstantial as not to require further argument. Despite the absence of a conflict in the circuits, the Supreme Court, not surprisingly, agreed to hear the case. Argument took place in January 2016. By the end of the argument, it was perfectly clear that Abood would be overturned by a vote of 5-4. Justice Alito, we can assume, received the assignment to write the opinion from Chief Justice Roberts. He no doubt turned quickly to that welcome task, finally achieving what he had set out so deliberately to accomplish. Then, the next month, shockingly, Justice Scalia died. There would be no majority opinion, not this time. By a 4-4 vote and a tie, the Supreme Court affirms the lower court judgment. The justices affirmed the Ninth Circuit without further discussion. Justice Alito would have to wait a bit longer, but not very long. Justice Gorsuch joined the court in April 2017. The National Right to Work Legal Defense Fund filed its petition in the Janus case. In June, the court granted the petition, and everything was off to the races. I'll just digress and say, who was this guy, Mark Janus, in whose name this case was brought? He didn't start out as the plaintiff. The first plaintiff was the newly elected Illinois governor. Here's where politics really coincides with law. Governor Bruce Rauner, a Republican who had run for office on an anti-union platform, backed by millions of dollars in contributions from an Illinois businessman, Richard Uihlein, who also helps fund the Federalist Society, the National Right to Work Legal Defense Fund, and a bunch of other organizations like that. With the state legislature controlled, on the other hand, by Democrats, Governor Rauner could make no headway with legislation abolishing the agency shop, which any state was free to do. In fact, more than half the states have abolished it. So he turned to the courts, but his lawsuit was dismissed because he had no standing. He was just the governor. He didn't like something that didn't give him standing to go to federal court. So Mark Janus, an Illinois state employee, was recruited and permitted to intervene as the new plaintiffs, and the case was on its way to the Supreme Court. So of course, the hurdle that Justice Alito and his 5-member majority had to overcome was the rule of precedent, the Latin term stare decisis, meaning to stand by that which has been decided. So here was a decision more than 4 decades old that had been reaffirmed many times. What to do? Justice Alito did something quite remarkable. He cited himself to show that any reliance interest that had attached to Abood had been erased by his own dicta. He went on to describe the fate of the Friedrichs case, and he said, during this time, any public sector employee union seeking an agency fee provision in a collective bargaining agreement must have understood that the constitutionality of such a provision was uncertain. In her dissenting opinion, one of her strongest ever, Justice Kagan called Justice Alito out, referring to the court's, quote, 6-year campaign to reverse Abood, and observing that the majority had found no special reason for doing so. Quote, it has overruled Abood because it wanted to. She continued, the majority has chosen the winners by turning the First Amendment into a sword and using it against workaday economic and regulatory policy. The First Amendment, she said, was meant for better things. So I've delved at such length into this history to make clear the aggressive nature of the court's attack on the status quo, a status quo anchored in democratic accountability. Because as I mentioned, states have been free from the beginning, either to adopt the agency fee system for their public employee unions or to reject it. Governor Rauner lacked the political power to accomplish his goal by legislation, so he enlisted a friendly Supreme Court. So it's a problem for the legitimacy of the courts, to be sure, but what we're seeing here, I think, is the start of my discussion of the court as a threat to the foundation of civil society. So I ask you to keep in mind Justice Douglas's phrase, as quoted by Justice Stewart, the furtherance of a common cause. Stepping back from what Janus tells us about labor law or the First Amendment, I think its primary injury is to further constitutionalize the notion that we as a society are not in fact united in a common cause, that we can help ourselves to an opt-out of our choice, that we're not all in this together. There's been much talk about the rise of tribalism in the United States and elsewhere. We retreat to our living rooms where alternate visions of reality greet us from across the airwaves, from cable connections, from the internet. It's increasingly hard to sustain the structures of civil society under these conditions. The Supreme Court once had an insight, as embodied by Abood in the cases that followed it until very recent years, that while we may disagree with one another, we're all playing by the same rules. That's no longer true. When did it stop being true? It's not possible to pinpoint a moment, but it was certainly well before the 2016 election. The story of the Religious Freedom Restoration Act is instructive. Congress passed this law, which is known by the acronym RFRA, Religious Freedom Restoration Act, to reject the Supreme Court's 1990 decision, Employment Division against Smith. In Smith, the court, by a vote of 5-4 with a majority opinion by Justice Scalia, held that the Free Exercise Clause does not offer a religious exemption from a law of general applicability. The case arose when the state of Oregon refused unemployment benefits to 2 members of the Native American church who had been fired for using peyote in a religious ritual, hallucinogenic peyote. Oregon's position was that people who become unemployed through violating a criminal statute were not entitled to benefits. The plaintiffs claimed the right to the benefits under the First Amendment's free exercise clause. Writing for the majority, Justice Scalia acknowledged that the men's claim was a sympathetic one that Oregon might well have chosen to accommodate, as he noticed other states had done in similar circumstances. However, he concluded, and I'll quote from the key paragraph, quote, "But to say that a non-discriminatory religious practice exemption is permitted, or even that is desirable, is not to say that it's constitutionally required, and that the appropriate occasions for its creation can be discerned by the courts. It may fairly be said that leaving accommodation to the political process will place at a relative disadvantage those religious practices that are not widely engaged in. But that unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs." Well, this decision alarmed religious communities across the spectrum, from the most liberal to the most orthodox. The result was the Religious Freedom Restoration Act passed in 1993. Liberals were fully on board with this project of congressional triumphalism. The measure's chief sponsor in the House, where it passed unanimously, was then Representative Chuck Schumer. In the Senate, where it passed by a vote of 97-3, the chief sponsor was Senator Ted Kennedy, and President Bill Clinton promptly signed it into law. RFRA provides, as the Employment Division against Smith case did not, quote, "Government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability," unquote, unless the government demonstrates that the policy or practice serves what the law calls a compelling governmental interest. So what amounts to a substantial burden? By what test? How are courts to evaluate whether a challenged policy imposes the least possible burden on religious adherents? Is every religious claim equally weighty? What does the Establishment Clause have to say about this hyper-vigilant protection of free exercise? These questions went unanswered, and in fact, they were scarcely raised. But Justice Scalia's warning came to pass. The political context in which RFRA was deployed changed dramatically during the following 2 decades. What its sponsors intended as a shield to protect minority religions became instead a sword in the hands of powerful forces representing the religious right in the Catholic Church. What we have now indeed is a statute that permits, one might say encourages, what Justice Scalia warned about. Every conscience is a law unto itself. The Supreme Court's Hobby Lobby decision from 2014 is really the case in point. The owner of a chain of craft stores with thousands of employees around the country claimed that under RFRA he was entitled to an exemption from the Affordable Care Act's requirement to include contraception coverage in his employee health plan. He raised a religious objection to certain forms of birth control that he deemed incorrectly to be abortifacients, to bring about an abortion of early pregnancy. In an opinion by Justice Alito, the court held by a vote of 5-4 that the owner of this for-profit business was entitled to the same accommodation that the Obama administration was offering to religious affiliated nonprofits. Of course, churches themselves were completely exempt. These organizations have been given the option of informing the federal government of their objection to contraception coverage, at which point the government would notify the insurance company to pick up the cost directly. In other words, hands off. The court held by a vote of 5-4 that the existence of this accommodation demonstrated that there was a less burdensome way of doing it within the meaning of RFRA. And so the Obama administration was ordered to make that change. And it's important to underscore exactly what the claim was, both here and in the cases that followed. Obviously, nobody was forcing Hobby Lobby's owner, or in subsequent litigation that led to this summer's decision in the Little Sisters of the Poor case, to buy or use birth control for themselves. Rather, the claim is one of complicity in the sin of third parties, what my colleagues at Yale, Douglas Nijame and Reva Siegel, call a complicity-based conscience claim. There's 2 points to note about that. One is the increasingly attenuated nature of these claims. Consider Kim Davis, the Kentucky county clerk, who acted under what she called God's authority when she refused to perform her duty to issue marriage licenses to anyone legally entitled to marry, including same-sex couples. That was a straightforward complicity claim. My signature would enable your marriage. The claim put forward in the months and years following Hobby Lobby, however, were much more attenuated. Some employers asserted that simply substituting an opt-out form to the government made them complicit, while others objected to the proposed workaround by which the government would act to assure contraception coverage without even any formal notice at all. On this logic, it's difficult to say where the chain of complicity would end. It's hard to see why an employer could not claim complicity in sin when issuing a paycheck that a female employee of childbearing age might predictably use to buy birth control products. And the second point is that the burden of permitting the employer to opt out falls on third parties, the female employees whom the law was supposed to protect. Justice Ginsburg, in her last dissenting opinion, emphasized this point in the Little Sisters case. The government, she argued, quote, may not benefit religious adherents at the expense of the rights of third parties. But her argument fell on deaf ears. So it may seem a stretch, and I'll wrap up now, to draw a line from Janus to birth control. And I don't expect that everybody will agree with my take on these cases, but I think they raise the same question. Will the Roberts Court further accelerate the tribalizing of America? Or will this fractured court find a way to invoke constitutional principles that help hold us together, all passengers on the same boat in stormy seas? Quote, a democratic society cannot flourish if its citizens merely pursue their own narrow interests, the political philosopher Robert Audi wrote 20 years ago. The Supreme Court, in its role as a Republican schoolmaster, in Robert Dahl's classic phrase, is an indispensable partner in the ongoing project of translating into operative law the values that vie for dominance at any given cultural moment. When the court moves from understanding to the First Amendment as furthering a common cause to enlisting it as a tool that individuals can invoke to free themselves from the bonds of a joint enterprise, something important has changed. I would argue that something important has been lost. Aren't we all in this together? And the answer to that question, I think, lies not only the future of civil society, but of democracy itself. Thank you very much. I'd be interested in taking your questions.
Thank you so much, Linda, for sharing all that with us. We'll give you a moment to hydrate. There's a lot to think about there. There's a lot to think about. So I think I'll ask one quick question to start us off, and then we'll turn it over to one of our brilliant students, Ben Vagel, who's been fielding all of your questions. You would be pleased to know that 2 years ago in my law and courts class, we did indeed talk about Janus. And I have seldom heard it discussed since then. I know my colleague Julie Kalish has spent a bunch of time thinking about Justice Alito's work on that as well. But it's a question on that and a question about the legal movements behind the Alito push that you've described and the success and the sort of imbalance there. And so you might think that Alito wasn't coming up with this on his own. This is part of a long project with institutional support beginning in the early 80s. And there was groundwork, there was scaffolding, and ultimately it leads to this First Amendment Lochnerism that you've described here and appropriately warned us about. And so I wonder if this points to two failings on the other side, on the left, where and here are the suggestions. One is that the Federalist Society has been working at this since the early 80s. And ACS was maybe 20 years late to the game. But the more substantive point is that some might claim that while the right was coming up with narratives to allow the court to expand, or the court to issue decisions consistent with a libertarian economic ideology, the left lost sight of the fact that the court is an important site of economic justice, in the words of the left, right? The legal left might have prioritized other issues over economic justice issues that it had previously taken to the court. And so I wonder if you think those are two strategic failings of the left that have contributed to the Janus type success you've described.
Yeah, so you use the word narrative, and that's really important. The right has been fabulously smart and successful in coming up with narratives. I mean, just think of this case, Little Sisters of the Poor, this summer. So for one thing, that's a great name for the case. And there was quite a struggle. There were many, many plaintiffs in that litigation. And I don't know, they just kind of got lucky that the case ended up being called Little Sisters. And this is an order of nuns who run nursing homes in which they don't have a religious test for who they care for or for who they employ. But yet the narrative was, oh my gosh, the big, horrible federal government is forcing these nuns, like shoving birth control down the throats of these nuns. And of course, the reality was totally far from that. So recruiting people like this one individual, Mark Janus, the preceding case, the Friedrichs case, were 8 or 10 school teachers in California. It's the same way the right recruits the attractive white plaintiffs who challenge affirmative action, or, you know, the cases that are going on against Harvard and Chapel Hill, claiming that there's discrimination against Asian applicants. These are just so brilliantly designed. And you're absolutely right. I mean, the asymmetry is stunning. The left had other priorities, certainly reproductive rights, civil rights. And I think the power of the libertarian movement really eluded the left as it was building steam and creating the infrastructure that I kind of alluded to in the talk, the interlocking directorate of the money going to all those groups that filed at front of the court briefs and all that kind of thing. So yeah, it's a tale. It certainly lies at the intersection of law and politics that you teed up at the very beginning, and it's very much worth pondering for the future because you know, we're going to see big changes. So, absolutely.
Thanks so much. I think I will turn it over to my colleague Ben Vagel for a moment.
Oh, you're muted, I think.
Hey, Ben.
Yeah,
Ben, I'm going to step in for a moment while you work on your microphone. Okay.
Okay. Yeah.
Great. So I'll throw out another question while Ben checks on his audio. So another important claim that you made in the second half of your talk is that you know, these exceptions for individual conscience that have just been expanded sort of beyond the bounds of what one could have thought from the original cases or the congressional grants of power are really bringing us apart. And you've written about this, so I think I know in some sense how you might respond, but a number of people might claim that even in the midst of that and intense polarization and difficult cases, Justice Roberts has at minimum, at key points, tried to bring us together. And of course, as somebody who studies healthcare, I would point to his attempts to, in large measure, sort of save the ACA. Others could point to other things, but do you think it's credible to claim that on the one hand, there are these forces sort of pulling us apart in the Supreme Court's recent jurisprudence, but there are sort of some political moves, particularly by the Chief Justice, to secure a majority of 9-0 cases and in high profile cases about things like the ACA to at least keep us together?
Well, I don't know. I'm not feeling quite that generous, I guess, because as you know, because I think you've read my recent stuff, I've been very concerned about the trend in the court's religion cases. So basically what we've seen is the free exercise clause, and this is totally part of John Roberts' project. He's no moderate. He's not looking for middle ground on this. We've seen the free exercise clause be so energized that the establishment clause, the other one of the two religion clauses of the First Amendment, has basically been effaced. I mean, when's the last time that the court held that something amounted to an unconstitutional establishment of religion? So, you know, bringing us together over the healthcare case, I don't know. I mean, you know, the other part of his opinion was that in the first healthcare case was that the Medicare expansion was coercive on the state against the states and was unconstitutional, and that enabled basically the red state governors to opt out and deprive, I mean, millions of their citizens of the ability to take advantage of the Medicaid benefit that wouldn't have cost them anything. The federal government was picking up the entire cost of it, but for ideological reasons, they said, no, we don't want it. And that was enabled by the way the Chief Justice played that case. And so, you know, our hopes reside in him at this point. It's kind of a slender read. I wish him the best. I have to assume he's one of the most unhappy people in the entire country, because what a burden this is going to be. You know, I credit his good faith. I respect the guy. But I think at these key junctures where his institutional role runs up against his priors, his substantive projects, it's painful. But I think if anything, you know, we're in the opt-out culture. I'll just say one more thing on this Little Sisters case. The court made very light of, so it's a religious opt-out, but then it's just an ordinary, I prefer not to opt out. Neither in the Trump rule nor in the Supreme Court's opinion, which is written by Clarence Thomas, is there any definition, any sense of limitation on what an employer has to show in order to just say, I don't want to do this. And the court just went along with it. And I just find that, I don't know, breathtaking. When I picked up the opinion, I mean, I knew how it had come out. I mean, you know, it was on C-SPAN or whoever was broadcasting the court that day. And I assumed we were going to learn a little bit about, you know, what kind of, quote, moral opt-out was going to be permitted. But no, just, okay, it's all okay. So that's where we are.
Thanks so much. I will try to turn it back over to my colleague, Ben Bagel.
Can you hear me now?
Yep.
All right, all is well. Well, we have a question from Sarah, who asks, in your view, regarding both the Supreme Court and the nation at large, does America still have a common cause? Have we shifted from having different ideas about how to achieve the same cause to simply having different ideas and different causes? And I'll add to that, what does this mean for democracy?
Yeah, that's a very good question. That's really the money question. And I have to say, I'd be kind of hard pressed to define the common cause that is going to unite us. You know, I grew up at the height of the Cold War, and there was a lot that was problematic about the way the country was behaving in those days, but that at least gave a kind of a framework in which we all thought, you know, the job of the United States was to save democracy against the forces of other systems. We don't have that organizing principle now, and I'm hard pressed to define an organizing principle. So I have not come to, I'm not in a restful state about the state of our democracy for kind of the reasons I gave and the reasons that very good question opens up.
Yeah. So we're all, of course, deeply saddened by the passing of Justice Ginsburg and are wondering what is to come in the aftermath of that. And in that vein, Thomas is asking you to address the issue of packing the court, which is obviously very conceivable if Justice Ginsburg's seat is filled by a conservative and then the Democrats sweep into Congress and the White House next year. What are your thoughts on that issue and what potential dangers does that pose?
Yeah, so I mean, here you're asking me to sort of, step out, just speak to you as a concerned citizen. My thoughts on this have evolved pretty quickly over the last couple of days. They've got the votes to ram the nomination through. Lindsey Graham, the head of the Judiciary Committee, says he's going to start hearings in 2 weeks. I think if the Democrats take the Senate and the White House, it'll be hard to resist the notion that there were 2 stolen seats, the seat that went to Justice Gorsuch after Mitch McConnell blocked President Obama's 10-month-long nomination of Merrick Garland, and this seat now, which by the same principle, the president should not even have thought of filling. Just as a citizen, I was not on board the court packing idea, but I think, those of us who consider ourselves progressives really have to think about it. So what are the dangers? Of course, the danger is it just turns the court so obviously into a political football. And when the pendulum swings, as it seems inevitably to do, and conservatives are in control and they don't like the balance of the court that was enabled by growing from 9 to 11 or 13, I guess some people are talking. Then do they make it 15 or 17? I mean, it's just hard to know where this kind of thing could stop. And does every election become a referendum on the Supreme Court? And what does that do to the court? It's really frightening. It's a terrifying prospect. I mean, we need a Supreme Court that people can have confidence in is a law-giving institution that's driven by something other than rank partisan politics. And it has been hard to hold on to that notion in these recent years when, for the first time certainly in modern history, the ideological divisions on the court have mapped totally onto the partisan identification of the president who appointed each justice, by which I mean the 5 conservatives all appointed by Republican presidents, the 4 liberals all appointed by Democratic presidents. That has not been our historic case. There's been, Earl Warren, the great progressive chief justice, appointed by a Republican president. Harry Blackmun, the justice who wrote Roe against Wade, appointed by Richard Nixon. So, the public could look at the court and see something other than a bunch of politicians in robes. And with court packing, it's going to be even harder to keep some kind of belief in the Supreme Court. We're entering a new, really dangerous, but I guess from a political scientist's point of view, totally fascinating period.
Yeah, absolutely. We live in such a remarkable time, and I appreciate you viewing it as a political scientist, because I think that's the only way one can sleep at night. To quickly make a request, we have a ton of interest from the audience and asking you questions, and we want to be respectful of your time, but would you potentially be able to stay 5 to 10 minutes over to take
sure.
more questions?
Yeah, sure. My talk is kind of long.
In that case, Lisa is asking, kind of building off of this court packing question and the polarization of the court in general. From what you've seen, what is the best way to address the polarization of the court? Or, given everything that's already happened, is an unpolarized court no longer possible for our democracy?
Well, I think the best way, and there's no good way, but if you look around the world, what makes a successful constitutional court in a thriving democracy. So for instance, the Constitutional Court in Germany is very highly respected, filled with highly respected justices. That system requires a supermajority to confirm somebody to that court. Now, of course, Republicans got rid of the filibuster for Supreme Court nominations. The filibuster served a purpose. When you take away the filibuster, the president can go as far to his, let's say his or her, notionally, political preference as far to the extreme as possible and still get 50 votes plus the vice president makes 51. There's no check on that. If we had had the filibuster in effect, Justice Gorsuch and Justice Kavanaugh would not have been confirmed. And the president would have had to go back to the drawing boards and find somebody that he could sell to a broader range of senators. Now, certainly the Democrats, if they take control of the Senate, are not going to engage in unilateral disarmament. They're not going to bring back the filibuster, obviously. So that's a theoretical notion of how to address this problem. I cannot imagine that it would actually happen. It's going to take, I think, real qualities of leadership by the Chief Justice and the other members of the court in being able to speak to the public in ways that the public can understand as, you know, we're speaking to you from law, we're not speaking to you from politics. There was a bit of that in the decisions this summer on President Trump's amenability to legal process from the district attorney in New York. That was important. They've got to find other ways of assuring people that they're there to do the job of interpreting the law.
Yeah, let's hope we have the right leadership needed to steer us through these turbulent times. Satchel is commenting on the friendship between Justice Ginsburg and Justice Scalia, and is wondering if, you know, in this time of intense political division, we should be emphasizing these really civil, cordial relationships between people from different ideological standpoints. Do you think that could kind of help to heal this divide?
Does the question mean people on the court or just all of us generally in the world?
In general?
In general?
Yeah.
Well, yeah, I mean, that's certainly, you know, true. I mean, as a journalist, I always tried to sort of play nicely with people from organizations not on my preferred side of the street, because like I might learn something. And I did learn, I mean, I have learned a lot from them. You know, not easy to sustain that. You know, in the court itself, I think people maintain civil relations because, you know, they're all grown-ups and they realize you can't get anything done on the Supreme Court unless you get 4 people to agree with you. So you can't just sort of go off in the corner and sulk if you've lost, if your way in a particular case has not prevailed, because the next case is always the next case. So maybe that's kind of a model, but you know, it doesn't look like that is sort of working in our politics today. Certainly not.
Yeah. Well, is what's happening with the court currently a sign of democratic backsliding? This is another question from Lisa, and I think it's a good one that's worth thinking about. Or is it more just a sign of partisanship? Have we experienced disunity like this before?
Well, we've seen crises involving the court before. We certainly did in the New Deal time. You know, I guess one difference there was we had a president and a strong majority in Congress, and the thing sort of righted itself. So, you know, Democratic backsliding, I mean, I think it's certainly the case that the structures that the framers set up in the Constitution, in their view, obviously, I mean, their view of democracy is different than our view of democracy, but are not working. I mean, the Electoral College has brought us presidents who didn't get the majority vote, and if assuming the current project to get somebody new on the court in the next few weeks succeeds, we'll have, let me count, 5, the majority of the court put on the court by presidents who do not receive a majority vote, confirmed by majorities in the Senate that did not represent a majority of the American public because of the, you know, every state gets 2 senators. So those structures are not serving us particularly well. And the question of what to do, of course, the one thing that can't be amended under the Constitution is the 2 senators from every state. So unless we're going to start from scratch, which I rather hope we're not, I'm not sure how to fix it. It's a deep structural problem among other problems right now, I think.
Absolutely. Well, we're almost out of time, and I'm going to give the last question to Professor Nauclis, who is going to take it from here. Thank you so much.
And actually, our last question comes from our colleague, Adina Roskis in the philosophy department, who you probably know from New Haven.
Indeed.
And so Professor Roskis asks, she's interested in hearing your reaction to the suggestion of Stephen Calabresi and others to transition to a court where justices are appointed for a fixed 18-year term.
Yeah, I think it has a fair amount of merit. Life tenure is really an anomaly in the world. There's no other country that has life tenure for its high court. There's no state that has life tenure for its high court except one, Rhode Island. You know, so there's a theory that's in the Calabresi op-ed, but also he wrote a famous law review article about this about 15 years ago, that it would kind of lower the temperature if we knew these people weren't going to be there for life. On the other hand, 18 years, it's quite a long time. It's worth thinking about. You know, the advantage of it, I guess, is that under an 18-year term, every president would be guaranteed 2 appointments. The downside of that is that makes every presidential election a referendum on what do you want out of the Supreme Court. So, you know, it's certainly not going to solve our problems, but I think, you know, could make things marginally better, I guess. The question is how to get there. There's a big debate in academia over whether it would require a constitutional amendment, since life tenure is baked into Article 3, or whether there's some kind of workaround that you could have 18-year active sitting terms, but the ones who are termed out would remain fully paid, fully accommodated Supreme Court justices. They would just be sort of in reserve. And I don't know if that flies. Some people think it would. That's just a matter of statute. So, you know, there's a lot of devils and a lot of details to that proposal.
Brilliant. Well, I'm going to send my final thanks over and turn it over to our colleague, Joanne Play.
Wow, that was so much to think about. That was a great, great talk. I want to thank you so much for spending a few extra minutes with us. I want to thank everybody in the audience for attending, and I'm sorry there were so many more questions than we had time for. We would have had to keep you here for another 4 hours, but I do want to mention that immediately following this, our capable questioner, Ben Vogley, is going to be interviewing Ms. Greenhouse, and that will be the basis of a podcast episode. So you may get more answers if you want to find our podcast, which you can find on iTunes, SoundCloud, and Spotify. It's called Rocky Talk. So look for that. Thank you to Ben and Professor Naklis. You handled questions so well. Ms. Greenhouse, thank you so, so much. That was a great Constitution Day talk. You've given us a lot to think about. Thank you so much for your time. And while I've got the mic, I'm just going to plug our next week's event. I hope you all can join us. We will be having the Perkins Bass Distinguished Lecture given by UNH President Emeritus Mark Huddleston. And the title of his talk will be Higher Ed in America, an Existential Crisis. So we hope we'll see you again next Wednesday at 5. Thank you, everyone.